How can a dispute be resolved in the workplace? We're going to call that the dispute resolution process. And what that is a dispute resolution procedure. And what that means is there's got to be a formal process that enables employees to complain to their employers about matters that affect them and their work. And in fact, the Fair Work Commission requires all awards and enterprise agreements, they must have a dispute resolution procedure in them before the Fair Work Commission will ratify or approve them. So when we looked at how awards and enterprise agreements are made, we said they've got to be ratified or approved by the Fair Work Commission. And part of that is they've got to have a grievance or dispute resolution procedure in them. However, it is optional for an individual contract to have this in there. How would it work? Well, let's take an example. Now, everyone's going to be different, but these are how we're going to treat it. We're going to say, look, if we've got a dispute, ideally, that should be resolved first of all with negotiation. That's just where the employee and their employer try to resolve the dispute very informally within the business, maybe at a meeting and a sit down, that sort of thing. Now, if that can't resolve it, because that's the ideal situation, we just sit down informally and they talk to each other and we resolve it without the need for involving any third party. We'll talk about who a third party is in a second. So that would be the best one, negotiation. But if it doesn't work or resolve it, we need to go to something called a grievance procedure. It might have a slightly different name in your textbook, but we're going to call it grievance procedure. And that is where the employee and employer resolve the dispute through formal preset procedures. And that's what's got to be in that contract at the Fair Work Commission. There's got to be a series of steps in there that say, all right, you couldn't resolve it informally. How can you resolve it formally, and what are the procedures for doing that? Now, if that doesn't work, then we need to go to a third option, which is called mediation. That's where an independent third party will work with all the parties involved, so the employee and employer, and help them figure out the best solution for everyone. So you're just facilitating communication between the parties who are in dispute and helping them decide. What if that doesn't work? Well, then we go to arbitration, and that's kind of the nuclear option. That's basically court. So we can think of arbitration, if you're doing legal studies, as just like a court case. It's where an independent third party, it's called the Fair Work Commission, arbitrates all rules. So arbitrates just means a word for ruling, makes a decision or ruling about the dispute by listening to both sides of the argument, then makes a decision on how to resolve it based on these arguments. So just like a court case and a judge, that's what a judge does in every court case. So when resolving a dispute, it is important to recognize who the parties involved are, because we're going to use the word third party a lot. What do we mean? Well, we'll say the first party, that's the employee. They can also have a representative if they want one. So let's say they're in the union, they can have a union there during a dispute to represent them, or maybe another senior employee. That's the first party. So who's the second party in a dispute? Well, that would be the employer, represented by the management. So they're the two parties in dispute with each other. So hopefully they can resolve it together, just with only these two parties. And what we say is, hopefully they can resolve it through negotiation, or if that doesn't work, a grievance procedure. But when those first two options don't work, it gets a little murky, because now we need to involve a third party, and that is another party to help the first party and the second party resolve their dispute. And how will they do that? They'll either do it through mediation, but if that doesn't work, then we go to arbitration. So that's kind of the whole dispute resolution procedure. However, we probably need to know a little bit more, not about negotiation, let's just have a chat, but what about this grievance procedure, mediation, and arbitration? What do they mean? So if negotiation is not successful, we need to go to the grievance procedure. That is where the employee and employer resolve disputes at the workplace through formal preset procedures. If that doesn't work, go to mediation, where we have an independent third party. We'll work with all the parties involved to help them figure out the best solution for everyone. If that doesn't work, then we go to arbitration. Independent third party arbitrates or rules over the dispute by listening to the arguments, then makes a decision on how to resolve it based on these arguments. And we'll say together, these represent the dispute resolution process or procedure available to resolve workplace conflicts and disputes. So let's go through them. Grievance procedure, what is it? We said preset procedures to resolve a dispute. So for example, that could be step one. The employee submits a complaint to the manager, and hopefully they can then resolve it. If they don't, we need to have a step two. For example, that might be, if unresolved, the complaint goes to the Human Resources Department or head office. And step three might be, if it's still unresolved, then it goes to the grievance committee. There might be a panel set up of employees and managers who sort of make an informal ruling on that. And yeah, we're hoping that will resolve it. So who are the parties involved? We say the employee, and sometimes they have a representative, so a more senior colleague or someone from the union, directly with their employer. Where does it take place? We say that takes place at the business level. So maybe not literally inside the business, but it probably is. So this is all happening at work. What about mediation? That's where we have the independent third party help the first two parties figure out the best solution themselves. So who's involved there? Again, we've got the employee and their representative. We've got the employer, but then we have a third party who's acting as what's called a mediator to facilitate discussion between the parties. Where does that take place? Again, we say at the business level, like we don't need to go to court for this, is what we're saying. It's going to happen at work. Maybe not literally at work, could possibly be off-site in a neutral venue, but it's happening at the business level overall. And if that doesn't work, then we go to the awful option of arbitration. That's court. We go to court and the judge makes a decision. So who's involved? Again, the employer and their representative, the employer, but then we have that third party. And instead of being a mediator, they're being the arbitrator. And in Australia, that arbitrator has to be the Fair Work Commission. So where does that take place? Well, now it's not at the business level. We go up to this Fair Work Commission court in Canberra, and it takes place just like any other court case. Both sides make their arguments, judge comes out at the end and says, here's the decision. How else can we sort of distinguish these different types of dispute resolution? What is the role of the third party? Well, in a grievance procedure, there is no third party. The whole point of it is that we don't need a third party. We just get the employee and the employer to try and resolve the dispute without anyone else. What is the legal validity of this? So once they reach a decision, is that it? Is it written in stone? Is that the law? It's actually not. The decisions reached aren't legally binding. And in fact, we might resolve a dispute through a grievance procedure only to have another argument about the exact same thing later on because it's not legally binding. Mediation. What's the role of the third party? They are there to act as an impartial mediator to bring the parties together to facilitate communication and discussion of their differences. And what the third party is trying to do is get the employee and employer to come to a final decision on their own and come to that decision together. Now, that can be the Fair Work Commission if the two parties want, but you can also hire, there are specialised businesses that act as mediators that you can hire. The important thing to note is that they're meant to be impartial or independent. However, again, once we've reached the decision through mediation, is it legally binding? It's not. It's not legally binding. It's just kind of an agreement the two parties have come to. What about with arbitration in the court case? Well, that's where the third party has to be the Fair Work Commission. It's the courts. There's no way around that. And they're going to act as an arbitrator. They'll listen to the arguments from both sides and then make a final decision for them what the solution should be, just like a judge in any court case. And what's important to realise here is that because it's a court case with a judge, the Fair Work Commission's final ruling or decision is legally binding and both parties have to adhere to it.